Good morning, members of Parliament, support staff, visitors in the Public Tribune, radio listeners, TV viewers, and those following via social media, and also the members of the media too as well. Good morning to everyone. I would like to welcome everyone to the continuation of a public meeting number 18 for today, Friday, September the 6th, 2024. And of course, with us, we have the Honorable Minister of Finance, Ms. Marinka Gums, and her support staff. Good morning to you, Honorable Minister. At this time, we have a quorum of 8 members of Parliament. Let us please stand for a moment of silence. Thank you very much. I have received notice of absence from Member of Parliament Kevin Mingret. I've also received lateness as well, notice of lateness from Member of Parliament Arian. I think I saw another Member of Parliament who also said that they are late, but I saw him walking, but that's MP Duran, who will be here with us too as well, and lateness from MP Marlin. At this time, I will go over to notifications. I look at the Member of Parliament. Do we have any notifications from the Members of Parliament today? I see none. So therefore, we will go over to the agenda point. We have as agenda point for this meeting approval of the Outline Agreement ENNIA, including Annexes A, B, and C, which can be found on IS 621 for the parliamentary year of 2023-2024, dated April 9th, 2024. We also have on the agenda point the ratification of the decision list of the Interparliamentary Kingdom Consultation, IPKO, held from January the 7th to the 10th, 2024 in The Hague, in the Netherlands, which can also be found on IS 798 for the parliamentary year of 2023-2024, dated June 11, 2024. It is important to note that this meeting is a continuation of the meeting that started on June 27, 2024. Additionally, the meeting was scheduled to continue on July the 18th. However, it was decided not to handle the agenda point due to the tragic incident that took place on July the 17th, 2024. We go over to the agenda point 2, approval of the Outline Agreement ENNIA, including Annexes A, B, and C, which I mentioned can be found on IS 621, the parliamentary year 2024, dated April 19th, 2024. On April 19, 2024, Parliament received a letter from the Minister of Finance, the Honorable Minister of Finance, with the request for a public meeting of Parliament seeking the approval of the Outline Agreement Regulation, ENNIA, including its annexes A, B, and C. In this letter, the Minister of Finance noted that the Outline Agreement Resolution, ENNIA, necessitates a long-term financial commitment from St. Martin, and that she was making this request with great respect for Parliament, particularly in consideration of the budget authority established inter alia in Articles 100, 101, and 102 of the Constitution. It is important to note that Parliament held a central committee that commenced on September 27, 2024, and ended on April 15, 2024. All answers to the questions posed in the Central Committee was received by Parliament. According to the Outline Agreement, the agreement sets out the main conditions for a partial relaunch of various parts of the ENNIA group and a controlled settlement of former ECL with government and CBCS funding. The resolution. The parties commit to the full collaboration of the elaboration of the resolution and to constructively negotiate, approve, and comply with the relevant legal requirements in this regard. Keep it in mind, the urgency of the matter and within the limited time frame provided in Article 3. The agreement also states that the parties, by signing the outline agreement, confirm to each other that they will each commit significant resources and manpower to elaborate and eventually implement the resolution with high priority, including to take all necessary actions to mitigate the risk of the resolution. I go on. In Article 14 of the agreement, it states that before entering into this outline agreement, the parties have made this subject to obtaining the necessary approvals as prescribed by the applicable legislation and regulations, the state regulations of Curaçao and St. Martin, and the related national ordinances, and that the parties will take all actions necessary to appropriate to obtain these approvals as soon as possible. In the term sheets, which is Annex C to Outline Agreement, the agreement approval by the Parliament of St. Martin to the Outline Agreement Resolution ENNIA is taken up as suspensive conditions. Hence, the agreement point for this meeting today and the importance of Parliament approval is the matter. At the start of this agreement point, the Minister of Finance At the start of this agenda point, the Minister of Finance gave a presentation to Parliament on the outline agreement. Therefore, members of Parliament were given the opportunity to speak to the agenda point in round 1. The meeting was then adjourned to allow the Minister sufficient time to prepare to answer the questions posed. I now would like to give the floor to the Honourable Minister of the COM, the Honourable Marinka Gomes, to answer the questions posed in the first round. Minister, I don't have my glasses, so I'm having a serious problem. So I thank my SG Garrick for outlining and pointing out. I will now give the floor to the Honourable Minister Marinka Gomes to answer the questions. You now have the floor.
Mr. Chairman, Honourable Members of Parliament, Clifford, my support staff, persons in the Tribune, citizens tuned in via social media, radio, and under the sound of my voice, good morning and blessed day. I am here to provide answers to the questions posed by Parliament on June 27, 2024. Representatives of the Central Bank who were physically here on St. Martin on July 18 are now virtually following this meeting to assist with questions that they would be required to answer, as some of the answers have been prepared by myself and team, and some by the Central Bank. In addition to the answers, I will also be presenting an addendum to the outline agreement for approval by Parliament. I will detail this after having answered the questions posed. I have not shared this addendum with Parliament as yet, as on a technical level, there were discussions until the wee hours of this morning. We are now awaiting Curaçao's technical level approval prior to sharing this with Parliament. However, without this addendum, my stance on the current outline agreement remains unchanged. Firstly, I would like to reiterate and clarify that when I assumed office as minister, there was already a signed outline agreement. This agreement signed by the previous Minister of Finance, Artwell Arian, and then Prime Minister Sylvia Jacobs. The ENNIA agreement was signed on April 11, 2024, after the elections held in January 2024, knowing that a new government would be coming into office. This raises the question of whether there was a lack of respect for the Parliament of St. Martin, or if the minister who signed the agreement assumed that any Parliament and government would align with the decision. This is in contrary to Curaçao, where the government first received approval from its parliament prior to signing the agreement. As such, upon entering office, I was not in a position to renegotiate a contract which was already signed off by the government, or so I was told. My intent upon taking office was to understand the details of this pre-existing agreement, as I needed to be well informed to present it in the public meeting to Parliament. It was crucial for me as the current minister to grasp what the agreement entails and its impact on St. Martin. After receiving comprehensive information about this complex agreement, I formed my own opinion, which I have shared with you during my presentation. On July 8, I was informed by the central bank that they do not see a viable option to reach an alternative solution within the remaining time before ENNIA needs to cut payouts to its policyholders. They, the central bank, want me to ensure that the Parliament of St. Martin is fully aware of this situation. Essentially, we are in a tight spot, and their advice was that I should recommend Parliament to accept this agreement as is. My position having already been established, I could not, in good conscience, come to my esteemed members of Parliament and simply state to agree to the Outline Accord if I was not convinced myself. Not agreeing with the terms nor having to tie solving an ENNIA saga, mind you, a privately owned entity, to COVID loans. I stated before, and I will remain with the stance that while I don't bite the hand that feed me or contributes to my overall financial stability, this is modern-day slavery. And it was reasons like this why it was necessary for me to investigate this matter and can now present to you an addendum to the HLA. While I am conscious of the fact that the decision lies in the hands of Parliament, you now have an addendum that is much more financially beneficial to the people of St. Martin and, by extension, the St. Martin policyholders. Your positive decision towards this addendum would indicate you choosing St. Martin and its people first. I want to emphasize that I have been committed to finding a solution that is beneficial for St. Martin. As I stated previously, the policyholders were already secured through the agreement. However, St. Martin was not. With this addendum, they can rest assured that they will be taken care of by St. Martin, and St. Martin can be rest assured that they are now only paying for their policyholders and not saving ENNIA. Lastly, I think it is crucial that despite our political differences, we unite when faced with solutions that serve the best interests of St. Martin. Only then can we protect the interests of St. Martin's people. For anyone to suggest that I, as Minister of Finance, was trying to torpedo this agreement is, for lack of better words, utter nonsense. My goal is and will always be to provide Parliament and St. Martin with the full facts and impacts of any agreement, not half-truths. It is no wonder we are seen as inferior and not regarded as equal partners within the kingdom when we cannot even present a united front advocating for St. Martin's best interest. Mr. Chairman, I will now proceed in answering the questions. Question from MP Ludmila De Weaver. Getting an idea, her question was getting an idea what was needed, what is needed in year one, etc. When is what amount of money due? And this answer was provided by the central bank. On July 18th, the estimated yearly outflow to St. Martin policyholders was shared with Parliament. It is projected that the total amount of the pre-emergency regulation obligations to policyholders on St. Martin will amount to 123 million guilders in total over the next 50 years. Her second question Since 2019, no dividend was paid out because there was no money made, or was this allocated to something else? Did the government apply it to something else? Again, an answer by the central bank. No dividends was paid out in 2019 nor 2020 because there was no profit made. In each year that a profit was made, dividends was paid out in the past by the central bank. In 2022, 290,000 guilders was paid out to St. Martin. And her final question, collusion is in the past, assurance that this will not happen again. We are currently bailing out a company. Since this issue happened, was anyone paid, or were their payments on hold because of the ENNIA situation? Again, answer provided by the central bank. Since the emergency regulation was applied, ENNIA Caribbean Life has continued to meet its obligations to its policyholders. Policyholders were not allowed to transfer their capital to a new life insurance. That was the final question from MP Ludmila De Wever. On to the questions by MP Artwell Arian. It wasn't phrased in a question, it was more in a statement. He said he expected me to provide Parliament with a better solution. And today I am glad to state that I am here to answer the questions and to present the addendum to the outline agreement, which is an improved solution for St. Martin under the circumstances. His next statement/question. Last March, we were informed by the Netherlands of this situation regarding ENNIA and were told that a solution needs to be found. In July, this was accomplished. However, the initial agreement upon solution was rejected by CFT. We were then sent back to the drawing board. 3 months later, in September 2023, a new solution was found. This is the best solution that could have been found with the data available at that time. If there is a better solution, the current government has had ample time to find one. Mr. Chair, through you, I would like to address the Honourable MP's remarks. The MP stated that in March 2023, the previous government was informed of an issue with ENNIA. By July 2023, a solution was found but subsequently rejected by CFT, necessitating another round of discussions, which resulted in a new proposal by September 2023, spanning a total of 6 months. The MP mentioned that this solution was considered best based on the data available at the time. I wonder which data exactly the former MP is referring to, as I understood that he questioned why it was important for me to find out who these policyholders were and where they worked. I would like to clarify that this is important because I want to ensure that St. Martin is not being misled, which we were. I will not simply believe what I am told by the central bank. I will ask the necessary questions to obtain accurate and truthful information and have this validated with data requested and received. As Minister of Finance, after arriving to this addendum, my reaction is, imagine with more time and additional data, what more would we have uncovered that would better serve the interests of St. Martin and the policyholders. However, the time is up now. The MP has implied that this government had ample time to devise a solution since assuming office, if there is a better solution. To clarify, the former minister had 6 months to arrive at a solution. This government, however, was sworn in on May 3rd, and I, as a minister, came to Parliament on June 27th. During this period, my focus was on understanding the current signed binding agreement from the former Minister of Finance. However, I am glad to now have an addendum to the signed outline agreement, which was achieved in less than a month. Followed question by MP Arian. He stated, you mentioned that no one from your team was involved, and that's absolutely not true. Your senior legal advisor was the main person, one of the key individuals who took part in finding this solution. So I would like clarity on that. Was this person not involved, and did he not inform you of the process? Mr. Chairman, for clarity, I never stated that no one from my team was involved. What I said was, and we can refer back to the tape, and I quote, "Please note that I may not be able to answer all of your questions since neither I nor my colleagues here today." At that time, I had the colleague to my right and a colleague to my left. They were the only ones present at that time, and they were not a part of the initial discussions. Mr. Chair, through you, I would like to address the Honorable MP's question. It is correct that my senior legal advisor, who is present here today, was one of the individuals involved in advising on the solution. However, it's important to clarify the nature of his involvement. The legal advisor's role was to provide guidance and expertise, but the ultimate decisions and directions were taken by the respective minister. Advisors are there to provide the minister with advice. It is the minister's decision to either follow or not follow the advice. We're not obligated to adhere to our advisor's recommendations, and I, for one, will not hide behind my advisors for any decision I make as Minister of Finance. If a minister requests legal advice on a specific action, such as moving a glass from one place to another, the legal advisor will provide the necessary guidance to achieve that objective. This was the approach taken by the MP when he served as minister. My approach, however, differs. I asked the same legal advisor to provide me with a comprehensive analysis, including the pros and cons of moving the glass, for which I am grateful, eternally grateful. In this case, I ensured to attend all the meetings with the central bank, as well as the technical team alongside my team. It was also very important to me to not only assess the legal side, but the financial side as Minister of Finance. This allowed me to gain a thorough understanding of the agreement, which the former minister signed off on, and formed my own opinion. As the old proverb goes, measure thrice, cut once. This ensures that all potential outcomes and implications are thoroughly considered before making a decision. Thank you, Mr. Chair. Next question. In the beginning of the presentation, you made it clear that you had absolutely nothing to do with the solution, and my interpretation is that you are distancing yourself from that solution. I find it interesting that you distance yourself from a solution or a proposal when it's convenient, but you didn't distance yourself, for example, when the canteen for the receiver's office or the vacation allowance, etc. It cannot be that at convenience you distance yourself, but when there is a controversial topic, there is a distance. Mr. Chair, through you, allow me to respond to the MP on his statement of insinuating that I am distancing myself from this solution before us. On the contrary, I am deeply vested in finding the best possible solution for the people of St. Martin and the policyholders. Despite the statement that the HLE stands as is, today we now have before us an addendum. That's how deeply vested I was in finding the best solution for St. Martin, no matter how controversial the topic. In fact, it is precisely when my back is against the wall that my determination and resilience come to the forefront. While it is true that I was not involved in the initial discussions of this particular solution, my primary focus has always been on evaluating and improving upon the proposals before us. This is not a matter of distancing myself for convenience, but rather of ensuring that I fully understand and critically assess each situation to make informed decisions in the best interest of St. Martin. My commitment to St. Martin extends beyond any single issue. Whether it is the solution we are discussing now, the canteen for the receiver's office, or the vacation allowance, my approach remains consistent. I would like to make clear, if something is good for the people of St. Martin, I will acknowledge it, that it is good. And if I feel something is not in the best interest for the people of St. Martin, I will have the right to make it clear as well. I understand that you would want me to stand behind this agreement as is, but based on the information I received, I simply cannot and will not withhold the people of St. Martin of my honest opinion. I engage thoroughly, seek comprehensive understanding, and aim to make decisions that serve our people effectively. Thank you, Mr. Chair. Next question. In your presentation, You also mentioned that you sought advice from former Minister of Finance, Mr. Richard Gibson. What I would like to know is in what capacity was this advice received? Was it in his capacity as board member of ENNIA, who is also involved in this? Mr. Chair, again, I have to correct the MP through you. I never said I sought advice. We can refer to the tape for verification. What I said was, and what I stated was, that I met with the central bank, the technical team, and the former Minister of Finance. For clarity, the latter meeting was not for the purpose of seeking advice, but to gain knowledge and understanding. Our discussions were not solely focused on this matter. In my opinion, it would behoove any new incoming minister to seek an audience with their predecessors. If the MP would recall, I reached out to him as well. I thanked him for keeping the office as clean as he did and expressed my hope that despite our political differences and being on opposite sides of the political fence, we could forge forward with a sense of political maturity. I also informed him that if there were decisions or projects he believed in but were unable to complete, I will consider them seriously if I believe they serve the best interests of St. Martin and its people. I will endeavor to see them through, even if adding my own touch, if necessary. Thank you, Mr. Chair. Next question. The message I got from policyholders is, how can you go to the rat to ask questions about the cheese? How can you go to Ansari to ask how to fix problems by Ansari, caused by Ansari? Mr. Chair, through you, my intent was to gather comprehensive information and insights from relevant parties, including those with historical knowledge of the situation. It is crucial to understand the full scope of the issue and consider all perspectives in order to develop a well-informed and effective solution. Engaging with individuals who have been closely involved in the past is part of the broader effort to ensure that we leave no stone unturned in our pursuit of the best outcome for St. Martin and its policyholders of ENNIA. It behooves me, as we can also state, why did we go to the central bank and have their technical team primarily make the calculations and rely on the information from them as well? As we all know, they are also partially to blame as a responsible entity for supervision. Nevertheless, I would like to make it clear that I do not promote any bullying, and Mr. Gibson has not been prosecuted. As such, let us refrain from prejudgment. Next question. And of course, this was then, so last week, the MP stated, former Minister Gibson said the policyholders of ENNIA were never at risk. Is that the same advice you received? What other advice was given to you from former Minister Gibson? Can Parliament receive a copy of the minutes from said meeting? Mr. Chair, through you, let me clarify the circumstances surrounding the meeting with former Minister Richard Gibson. Firstly, I want to emphasize that I did not seek formal advice during the casual meeting with former Minister Gibson. This was an informal discussion held before I even took office, and therefore no official minutes were taken. Regarding the request for minutes by MP, it is important to note that not every informal or casual interaction requires the production of minutes. The purpose of such meetings is often to gain insight and perspective, which contribute to a broader understanding of the issues at hand. As for providing copies of minutes from the informal meeting, since no formal minutes were recorded, there are no official documents to provide. However, I am committed to transparency and will endeavor to provide any relevant information that can assist Parliament in its oversight duties. Thank you, Mr. Chair. Next question. It was also stated that Mullet Bay is valued at $180 million. What I would like to know is based on which appraisal is this information given? We've had 2 done in recent years and a 3rd one is pending. Can Parliament receive the latest appraisal? This answer was provided with assistance by the Central Bank. Mr. Chair, thank you for your question. MP, I appreciate the inquiry regarding the valuation of Mullet Bay. Although I do not have an official appraisal report at the moment, I can confirm that the amount mentioned was included in the appendix to the signed outline agreement. In addition, during my meeting with the Central Bank, I asked them where they got this amount from, and they confirmed that the stated amount of 180 million guilders is an estimate of future sales proceeds based on the most recent appraised value, and taking into account tax liabilities, etc. MP, again, it behooves me that you are not aware of this amount of the 180 million guilders, because it is key in the whole financial impact and assessment of the outline agreement, which was signed by your person. In the interest of transparency and accountability, I have discussed with the central bank if Parliament can be provided with insight into the latest appraisal of Mullet Bay. Taking into account the confidentiality, Central Bank is open to finding a way how this can be shared or viewed by members of Parliament. This will enable our stakeholders to have a clear understanding based on verified and updated information. In addition to this, I was informed by the Central Bank that the appraisal appointed by the judge will not be on the current value of Mullet Bay, but it is an appraisal to assess the past value of Mullet Bay that was stated in the financial statement in prior years to determine the overstated value of Mullet Bay at the time as included in the financial statements from ENNIA. Next question. Members of this coalition also discussed the expropriation of Mullet Bay land. You also indicated how important Mullet Bay is to us. Can you confirm that the Council of Ministers has had this discussion? Is there something we are truly considering? Has the process been started? What are the legal risks of this? Are there financial consequences of this? And are said consequences linked to the actual value of Mullet Bay? And where will we get the money from in terms of the financial implications of taking this action as opposed to buying it outright? Based on the current signed outline agreement, we have not been considered, or there was no advantage for St. Martin purchasing Mullet Bay. In addition, as included in my presentation, there is a conflict between Curacao and St. Martin on Mullet Bay, as they would want it sold for the highest. This is also the sentiments of the central bank, as they have to look after the interests of the joint creditors. I repeat that I deem it a missed opportunity that you were not able to secure any benefit for St. Martin when it pertains to Mullet Bay, and to my understanding, it is not that they were not willing, it is that St. Martin did not even ask. Hence, your question about if the Council of Ministers have had discussions is premature, as I was busy trying to understand what was agreed upon pertaining to Mullet Bay in this agreement. But yes, Mullet Bay remains on St. Martin, and directly or indirectly, we have a say in Mullet Bay, and we will look into the various possibilities for country St. Martin. After the presentation by my person on June 27th and discussions that I had with Central Bank, they stated that they have considered a way in which St. Martin could possibly be accommodated in the context of the current outline agreement, which is positive again, evidence that we have not exhausted all possibilities to benefit St. Martin. Next question. Then MP Grisha Helliger Martin urged us to not go through the Netherlands and instead to pursue refinancing of our COVID loans. Mrs. Helliger Martin mentioned that a Mr. Medema had informed the group that he had been having informal conversations with technocrats within the Dutch Kingdom and the Ministry of BZK, centered on the Dutch government granting a guarantee on the consortium to allow St. Martin to refinance our COVID loans, and that this approach was favorably received. Has your new colleague, Minister of TIAD, Mrs. Grisha Helliger Martin, informed you of this solution? Was the MOU that she presented also brought to the Council of Ministers? Mr. Chair, through you, I suggest this question be posed to the Minister of TIAD, as it does not pertain to the main agenda point, which is ENNIA solution. Next question. When you do have the information with regards to the potential refinancing of our loans, I would like to hear your opinion on this solution. Mr. Chair, through you, I had no discussion again with Minister Grisha Heliger-Martin on potential refinancing of our loans, and to be quite frank, there is no need to have such a discussion. The refinancing on our loan agreement was already signed off by the previous government. Next question. In your position as minister, do you believe that having meetings with persons listed on the document of the court case will have any impact of further ramifications on the outcome of the ongoing court cases? Through you, Mr. Chair, for the question regarding the impact of meetings with individuals listed in the court case documents, as Minister of Finance, it is important for me to engage with a wide range of stakeholders to gather insight and information relevant to our responsibilities. These discussions are conducted with transparency and in accordance with legal and ethical guidelines. Regarding any potential impact on ongoing court cases, it is essential to respect the independence of the judiciary and legal processes. Meetings I attend are focused on understanding issues and seeking constructive situations that benefit St. Martin and its people. I assure you that any actions taken are done so with careful consideration of their implications, including legal ramifications. Upholding the integrity of our legal system and ensuring fair proceedings remain paramount in all interactions. Based on the statement, discussions have been had with Central Bank, and they will be providing me as Minister of Finance with the information needed with regard to ongoing court proceedings. And based on the names provided to me as ongoing court cases, I can state emphatically that I have not had meetings with any of those persons mentioned by the Central Bank. Thank you, Mr. Chair. Next question. Are there any other persons listed on the document as board members that you have meetings with pertaining to the ENNIA case? Policyholders are concerned that the Minister of Finance is being advised by the same individuals responsible for their plight. Mr. Chair, through you once again, based on the names provided to me, I have not had meetings with any persons on the document pertaining to the ENNIA case, which was provided to me by the Central Bank. Next question. About the dividends, you stated that our finances as a country would continue to be impacted over the next 50 years. Is it not true that in addition to the original $4 million, we would also receive $1 million every year henceforth? Mr. Chair, through you, no, it is not true that in addition to the $4 million, we would also receive $1 million every year. However, it is true that of the $4 million, which should be paid out to St. Martin yearly, $3 million would go to paying out policyholders of St. Martin, and $1 million will come to St. Martin. That was the end of the questions of MP Arian. Questions by MP Duran. Can a list be provided of persons consulted for a solution to ENNIA issue? Through you, Mr. Chair, the matter in finding a better or feasible solution towards the ENNIA issue was extremely important. Therefore, I have several discussions with key stakeholders consulted for the ENNIA solution, such as the Central Bank and the technical team, as they are the ones that understand it and have all the data, or anyone who, especially during the election campaign, wanted to voice their concerns, policyholders included. Next question. What are the in-depth discussions when it comes to the sale of Mullet Bay, be it with Sun Resorts, the Central Bank? If this sale is one of the solutions that are being discussed, I would like to know what role does the government play in this process and how far along are they already? Mr. Chair, part of understanding the signed outline agreement was getting insight into the role of government when it comes to Mullet Bay. While we did meet with Sun Resort, it was an introductory meeting. Currently, based on the signed outline agreement, they have incorporated the sale of Mullet Bay as stated previously. No benefits for St. Martin has been agreed on this. However, now the government of St. Martin now has the right, the first right to purchase. Next question. During opening remarks, distancing herself from the situation, how is that going to work out as executive branch? You will have to make the decision. Clarity given on this. Mr. Chair, through you, this question was also asked by MP Arian, and my answer remains unchanged. Please refer to the question posed and answer provided. Next question. Sun Resort posted piece of the property for sale. Before anything put to sale, consult with the Council of Ministers. Is this still on the table? Clarification. What are the in-depth discussions when it comes to the sale of Mullet Bay? The sale of Mullet Bay is not changed by way of the outline agreement. Central Bank, in its role under the emergency measure, will continue to evaluate the best way forward for Mullet Bay, considering the goal of the resolution, which is to reach the best outcome for all creditors of ENNIA, including its policyholders. Next question. Minister seems to not be in agreement with the current agreement. What is your solution? What is the viable solution to bring to the 3,000 plus policyholders, or will you leave these persons up in the wind? I have briefly touched upon this topic with APS representatives who surprisingly informed me that they were never consulted officially. As such, my stance remained that I did not feel all options were exhausted. Now, while my intention was to seek alternative options, after having read and gained knowledge of the content of the short-term refinancing agreement signed by the previous government, whereby they agreed to linking the COVID loans to ENNIA. As such, my alternative would be a huge financial burden to Country St. Martin, which would cause our interest norm to be exceeded and prevent us from being able to make any investments for our country or providing our citizens with much needed tax relief. My solution, given the circumstances bound by the previous government, is in the addendum. Once the questions have been answered, I will provide the esteemed members of Parliament with a synopsis of the addendum and the significant financial benefits for St. Martin. MP Marlin. Why was the immediate former Minister of Finance, Mr. Arian, not consulted on this? Rather, I've noted that Mr. Richard Gibson was. My question is then, in what capacity was Mr. Gibson consulted? Was it as previous Minister of Finance, as a former Supervisory Board Director of ENNIA, or as the personal advisor of Mr. Ansari? This question was asked and answered. Next question. What is the current amendment or proposal that the Minister is asking Parliament to approve? Today, Mr. Chair, through you, I am asking Parliament to approve the amended version of the Outline Accord. I repeat, the amended version of the Outline Accord. MP Marlin continued, and at that time it was during the election, but I have to answer his question. DP celebrating 70 years of existence. In the 70 years, what have we seen? When today we are hearing about ENNIA, harbor, etc., in what all could have been built, etc. Mr. Chair, during the election campaign, the Democratic Party, with its list of 23 candidates amongst our leader, the Honorable Sarah Westcott Williams, with 30 years at the helm, made it clear to the citizens of St. Martin all it has done over the years, and more than ever, willing to continue doing on behalf of its people. I stand here today proud of the contributions and with a clear vision for continuing to build a prosperous future for St. Martin. Long live the Democratic Party of St. Martin, 70 years strong and 70 plus more to go. Mr. Chair, I believe I need to remind that on August 19th, the people have spoken. And I hope this second time around, we can now respect the wishes of the electorate. Questions by MP La Cruz. What exactly are we trying to approve? Answer, through you, Mr. Chair. Parliament will be voting on approval on this amended outline solution. Next question. The latest position of Parliament in January 2023 by MP Emmanuel and MP Bryson stated clearly that the interest of St. Martin and its people is always paramount and included in every decision regarding the sales of Mullet Bay property, and all options are explored. Is this still the case? Answer, Mr. Chair, yes, the interest of St. Martin and its people is paramount when it comes to Mullet Bay. Next question. If Curacao does not approve this plan, why is St. Martin still required to give approval? Has the government considered migrating the policyholders from ENNIA to APS, where the debts and asset swaps could cover both sides of each entity's balance sheets with future premiums? Mr. Chair, through you, the Parliament of Curacao did approve this outline agreement. As such, the final decision lies with the Parliament of St. Martin. Curacao, of course, is in a more dire situation than St. Martin, as they have 27,000 policyholders compared to us having 3,000 policyholders. Concerning APS, I have briefly touched upon this topic with questions posed and answers given. Next question. In addition, we hear 4 million in dividends, 3 million going to bailing out ENNIA. The question remains with Mr. Ansari losing court case after court case. Why are we doing this? Why
Honourable
are
Minister, if you would oblige, please, I have a Honourable Member of Parliament for an interruption. Honourable Member, you now have the floor.
It's on. A blessed morning. Thank you, Mr. Chair. Honourable Minister, I would still like the answer to the question because I've heard so much, shots being fired today. I'd rather, just my questions, please answer them because I stopped listening when all the shots were fired. Thank you.
Honourable Minister, you have the floor.
I have briefly touched, Mr. Chair, sorry, through you. I have briefly touched upon this topic with APS representatives who surprisingly informed me that they were never consulted officially. As such, my stance remained that I did not feel all options were exhausted. Now, while my intentions was to seek alternative options, after having read and gained knowledge of the content of the short-term refinancing agreement signed by the previous government, whereby they agreed to linking the COVID loan to ENNIA. As such, any alternative would be a huge financial burden to country St. Martin, which would cost our interest norm to be exceeded and prevent us from being able to make any investment for our country or providing our citizens with much needed tax relief. My solution, given the circumstances bound by the previous government, is in the addendum. Once the questions have been answered, I will provide the esteemed members of Parliament with a synopsis of the addendum and the significant financial benefits for St. Martin. I was at the question. In addition, we hear 4 million in dividends with 3 million going to bailing out ENNIA. The question remains with Mr. Ansari losing court case after court case. Why are we doing this? Why are we not seeking the funds from him? Mr. Chair, the central bank is currently in litigation against Ansari, and any proceedings from the litigation will reduce St. Martin's financial obligation towards our policyholders. I'm on to the next questions by MP Emmanuel. We had been asking for a recent appraisal report, so I am curious to know where the figure of 180 million came from. This question has been previously asked and answered. What exactly are you asking Parliament to do? Are you asking us to reject the agreement or to approve it? Mr. Chair, I am asking the 15 members of Parliament to support the amended outline agreement. What percentage of the central bank is owned by St. Martin? St. Martin has 22.22% shares in the central bank. A price tag attached to Mullet Bay, where did this come from? Have been asking for appraisal report. Where is the 180 million guilders coming from? Again, question previously asked and answered. Next question. What percentage of the central bank is owned by St. Martin? St. Martin is paying twice. Central bank also has to contribute as well. Does that include the 22% ownership of St. Martin? Where are they getting the funding from to make their contributions? Are we paying twice? Mr. Chair, through you, as stated in my presentation, all money paid out by the central bank is money from St. Martin and Curacao. As such, while it is stated that the central bank contributes this, it is not true that only ones contributing is St. Martin. The only ones contributing is St. Martin and Curacao. Central bank withhold part of the dividend from St. Martin and pays this on behalf of St. Martin to our policyholders. What happens to the dividends of 2020, 2021, 2022? Now the money is being made available to help pay. How is St. Martin benefiting? Why are we not going after Ansari? There were no dividends paid out in the years 2019, 2020, and 2021 because, according to the central bank, they did not make a profit. The case against Ansari is still ongoing. However, the potential funds received from this will not cover the full financial obligation to the policyholders. In addition, the previous Minister of Finance agreed that the complete profit to be made from the sale of the gold to be used to invest in the bonds would be stored in a reserve for future possible losses of the central bank. Again, nothing for St. Martin, true. However, rest assured, as the current Minister of Finance, notice was already given to the central bank that this matter will be addressed during the upcoming shareholders meeting. We have a problem? No. Excuse me, Mr. Chair. Yes, please.
Members of Parliament, we'll take a 5-minute break. Meeting break. We will now restart the meeting. Honorable Minister, I give you the floor. I hope your technical situation has been resolved. You now have the floor, Minister.
Thank you, Mr. Chairman. Yes, my technical situation has been resolved. And I was at a question from your person. Let me just repeat just in case. What exactly are you asking Parliament to do? Are you asking us to reject the agreement or to approve it today? I am asking the 50 members of Parliament to support the amended outline agreement. What percentage of the central bank is owned by St. Martin? St. Martin has 22.22 shares in the central bank. Next question, a price tag attached to Mullet Bay, where did this come from? Have been asking for appraisal report. Where is the 180 million guilders coming from? That question.
Honorable Minister, we have an interruption. Member of Parliament, Ms. Jacobs, you have the floor.
Yes, good morning, Mr. Chairman,
Morning.
colleagues, Secretary General, Minister, and Honorable Minister and support staff. More than once, I heard the Minister mention about a new agreement, while earlier an addendum was mentioned. Can the Minister please clarify whether it's the old agreement plus addendum or a complete new agreement that she's now referring to?
Minister? Yes, you'll have to answer the question now, yes.
Mr. Chair, through you, it is the old agreement with an addendum. You can only have an addendum based on something that was there prior to.
Thank you.
So it's the addendum along with the HLA previous.
You have the floor, Minister.
Yeah.
Yeah.
Mr. Chair, I know we discussed just a few minutes ago about questions asked and answered, but this is a question that you posed concerning the appraisal of the 180, and it was answered. Thank you. Next question, what percentage of the central bank is owned by St. Martin? St. Martin is paying twice. Central bank also has to contribute as well. Does that include the 22% ownership of St. Martin? Where are they getting the funding from to make their contribution? Or are we paying twice? Mr. Chair, through you, as stated in my presentation, all money paid out by the central bank is money from St. Martin and Curacao. As such, while it is stated that central bank contributes, this is not true. The only ones contributing is St. Martin and Curacao. Central bank withholds part of the dividend from St. Martin and pays this on behalf of St. Martin to our policyholders. Question, what happened to the dividends of 2020, 2021, 2022? Now the money is being made available to help pay. How is St. Martin benefiting? Why are we not going after Ansari? There were no dividend paid out in the years 2019, 2020, 2021 because central bank did not make a profit. The case against Ansari is still ongoing. However, the potential funds received from this will not cover the full financial obligation to the policyholders. In addition, the previous Minister of Finance agreed that a complete profit to be made from the sale of the gold to be used to invest in the bonds would be stored in a reserve for future possible losses of the central bank. Again, nothing for St. Martin. True. However, rest assured, as the current Minister of Finance, notice was already given to the central bank that this matter will be addressed during the shareholders' meeting. Question, who decided what St. Martin portion should be? Because the former minister kept saying it is not his agreement. Who made the agreement decisions that the portion St. Martin should pay is the good one, based on what that decision was made. Mr. Chair, through you, I am not sure if the former minister is trying to say that his prior legal advisor is responsible for the agreement. Nevertheless, I would like to remind the minister that it is his signature that is on the agreement, and that as the Minister of Finance, he was responsible or is responsible for what he signed off on. Next question. Work extremely hard to bring them over to APS. We can have APS instead of ENNIA. Mr. Chair, through you, I feel it is a missed opportunity by the previous government to not have consulted with APS before the signing of the refinancing agreement, which linked interests of the COVID loans to the solution of ENNIA. At this time, I will go to the questions of MP Roseberg. Seeing all the risk mentioned, will there be another solution presented with less risk, and in what timeline? Due to the risk mentioned, I am here today to present to you the addendum. Next question, are there any ongoing civil court cases? The Central Bank has initiated several legal proceedings in order to try to restore the financial position of the ENNIA Group in general and the ECL in particular, and to recover from the persons liable for the losses suffered under the rule of its former directors, former supervisory directors, and indirect shareholders. One of the main proceedings concerns the liability proceedings against former director and supervisory directors of ENNIA Group, including, amongst others, Hushang Ansari, former supervisory director of ECH, indirect major shareholder and de facto director of ENNIA Group, and against Parman International BV, shareholder of ECH. Other proceedings include the disciplinary proceedings against former accountants of the ENNIA Group. Next question. Are still current any criminal investigations ongoing with the ones involved in the ENNIA saga? In 2018 and 2019, the Central Bank has filed a report with the public prosecution. The investigation of the Public Prosecution Office is still ongoing. The reason that Mr. Gibson was consulted and in what capacity? Again, Mr. Chair, I have never sought advice. We can refer to the tape for verification. What I stated was I met with the Central Bank, the technical team, and the former Minister of Finance, Mr. Gibson. For clarity, the latter meeting was not for the purpose of seeking advice, but to gain knowledge and understanding. Our discussions were not solely focused on this matter. In my opinion, it would behoove any new incoming minister to seek an audience with their predecessors if the key. My apologies. There I stated where I answered the former minister and me reaching out to him. I don't think that part of the question, that part of the answer ties into the MP's question at this point. And her last question, the last question of MP Roseberg, how will this Hofleiner Court impact possible civil and or criminal proceedings? Pursuant to the outline agreement, the Central Bank has made and will continue to make efforts, such as by filing reports to enable a criminal investigation into those responsible for causing the former ECL solvency deficit, Article 11.1 Outline Agreement. In addition, the Central Bank has made and will continue to make efforts to recover damage as a result of causing the solvency deficit from all those liable for them, such as through instituting and enforcing the claim and other civil proceedings, Article 11.2, Outline Agreement. I will move on to questions by MP Severia Jacobs. Inform us if there are any other solutions that are possible that have lower risk for St. Martin. Although this was asked and answered, I just want to reiterate that the lower risk in this case would be the fact that I have now come to an addendum to the outline agreement. Next question by MP Jacobs. Government-owned companies that have fees such as airport or harbor that are staying in the company. What can we do about this? Mr. Chair, through you, Minister of TIAT, Ms. Grisha Helliger Martin, is addressing this and is ensuring that these entities pay country St. Martin fees owed. Question by MP Brugge. What were all the options that were on the table, whether with you or the previous minister? Do you have minutes of the meetings where these options were presented, and if that information can be provided to Parliament? Curacao, St. Martin, and the Central Bank have considered the following scenarios to ECL solvency deficit. A full relaunch. B, a controlled runoff. And C, a partial controlled runoff with a partial relaunch. I would go into each detail for clarification. So the full relaunch, ECL's new relaunch entity would immediately need a large capital injection of an estimated 1.2 billion guilders to fulfill the applicable solvency requirements. This could only be done through a loan from the Netherlands. According to Curacao, taking out such a loan would have placed too large a burden on Curacao budget, leaving Curacao with insufficient budgetary room to invest in its economy. B, which was a controlled runoff, has an important drawback, namely that the value of ECL would be extinguished to avoid a write-down of the pre-emergency regulation liabilities. A significant financial contribution would have to be made. No party was willing to do so because it would not get this contribution back. The runoff could also cause unrest in society. And C, a partial controlled runoff with a partial relaunch. Central Bank, Curacao, and St. Martin opted for the partial relaunch with a controlled runoff, as this was in line with the country's financing options. The capital injection required for ENNIA new is lower than under a full relaunch, as part of ECL will be relaunched and therefore a lower upfront capital injection is required. For the part to be wound down, no lump sum is needed, as the winding down of the portfolio is played out over a long time and the required contributions can be spread out. A major advantage is that the healthy part of ENNIA Group will be retained and can contribute to paying the pre-emergency regulation liabilities through the share certificates held by the Resolution Fund in Stichting Beheer, the shareholder of the new ENNIA Group. Next question. What is the possibility to go back to the drawing board to seek a solution, considering that ENNIA can continue to function without some form of intervention until 2025? The Outline Agreement does not provide room for negations on the terms and conditions agreed upon, considering, and this answer came from the Central Bank, considering the time it took to reach the present solution, 1. 2, the coordination necessary with third parties, example, the CFT and the Netherlands, and 3, the time needed to implement a solution, at least several months. There is insufficient time to go back to the drawing board to seek a different solution, a total different solution. Hence why today I come to the 15 members of Parliament on an addendum to what was already presented. The last question by MP Brugge. Population of approximately 42,000. We are talking about 3,000 policyholders. How can we not penalize the non-policy holders and go after the ones who are responsible and who benefited directly or indirectly from the loss of the 3,000 plus policyholders? Mr. Chair, I am in agreement. We need a solution that benefits St. Martin as a whole. I will move on to the questions by MP Westcott Williams. Can the minister provide a simplified summary and overview of the financial course of ENNIA Holding and its subsidiaries over the last 5 years, as well the projections going forward that led to the calculations resulting in the Hoofdlijn Accord main agreement. Mr. Chair, the annual contributions from Curaçao, St. Martin, and the Central Bank to the Resolution Fund will be used to pay the pre-emergency regulation liabilities. The main calculation, therefore, relates to the pre-emergency regulation liabilities. We are not able to share the financials of ENNIA as we face confidentiality limitations. Moreover, those financials are not suitable for calculations required for a solution consisting of a partial controlled runoff with a partial relaunch. Again, answers provided by the central bank. Question 2. What would the results be if, right now, the amounts due, according to the courts, from Hushang Ansari was collected? What difference would that make for the calculations currently on the table? The Joint Court of Justice of Aruba, Curaçao, St. Martin, and of Bonaire, St. Eustatius, and Saba recently confirmed in an interim judgment liability for an amount of 230 million guilders. Any proceeds from the claim on Ansari will be used primarily to meet the pre-emergency regulation liabilities. In the event 230 million is collected at this moment, this would not mean 15 million guilders to cover the contribution of St. Martin. Do note that the total effect of this amount is dependent on the allocation of these funds. In the same judgment, the court appointed an expert to further investigate the historical value of Mullet Bay in order to rule on substantial claims related to, amongst others, dividend payments based on an excessive value of Mullet Bay. Any proceeds from the claim on Ansari will be used primarily to fund the deficit at former ECL and to meet the pre-emergency regulation liabilities, as the amount to be recovered from Ansari remains subject to the further success of the litigation and subsequent enforcement actions. The litigation award has not been included in the cash flow projections. It is noted that the annual contributions may, if certain conditions are met, be temporarily or permanently adjusted downwards by the parties by mutual agreement if the assets of former ECL and or the resolution fund are sufficient to meet the pre-emergency regulation liabilities expected to become due and payable in the next 5 years. Third question. Can a government or parliament legally make such a long-term agreement without an escape clause if this entire picture turns out to not be as feasible as projected? Answer provided by the central bank. The outline agreement contains a provision provided for an interim review, Article 7.4 outline agreement. The parties will review the duration of the contribution 15 years after the implementation date and consult in good faith, if necessary, for necessary changes. However, there is no escape clause, as the solution should provide the confidence to the policyholders for the entire period. Is there an escape clause included in the outline agreement? So, question asked and answered. However, in addition, it is noted that the outline agreement and associated financing documentation assume that all parties will fulfill their obligations. Question 5. Can the ministry, can the ministry and the minister from the central bank provide the parliament with the financial projections of the central bank underpinning these dividend payments? Mr. Chair, through you, budget central bank for the coming 3 years shows expected profit and dividend payments. Under the outline agreement, the central bank's annual contribution is 15 million guilders per year for a period of 50 years. In order to pay this annual contribution of 15 million to the resolution fund, the central bank has to realize sufficient yearly profits to pay out a total of 18 million guilders in the form of dividends. Said amount of 18 million guilders is first allocated between Curaçao and St. Martin on the basis of the central bank distribution key, Curaçao 77.78% and St. Martin 22.22%. This means that 14 million guilders is allocated to Curaçao and 4 million is allocated to St. Martin. Therefore, or thereafter, the ENNIA distribution key, Curaçao 93.51 and St. Martin 6.49% is applied to calculate the respective shares of Curaçao and St. Martin in the 50 million guilder central bank annual contribution. Assuming a central bank annual contribution of 50 million guilders, the shares of Curaçao and St. Martin in this contribution are as follows: Curaçao 14 million guilders, St. Martin 9. Since the central bank distribution key deviates from the ENNIA distribution key, the difference between St. Martin's shares based on the central bank distribution key and the St. Martin share based on the ENNIA distribution key will be paid directly by the central bank to St. Martin. Based on the foregoing, this means that an amount of 3 million will be paid by the central bank directly to St. Martin in the form of dividends. Question 6. Based on what were the calculations made? What information was underlying? The central bank has made an investment of $456.8 million in U.S. Treasury bonds, earning an annual yield of 4.21%. The duration of this investment is 30 years. Question 7. Parliament of Curaçao unanimously approved and gave government instructions to sell the new ENNIA. If so, is that motion being taken into consideration? Answer provided by the central bank. The motion approved by Curaçao was intended to urge the government to support the sale of ENNIA New in a responsible way to reduce the contribution of the government into the solution. Question 8. How much is expected from the sale of the new ENNIA? There is currently no scheduled date to sell ENNIA New, and as such, no current expected amount from the sale of the new ENNIA. Question 9. Is it the intent to sell the ENNIA New in 2074? If the shares in ENNIA New are still owned by the Management Foundation in 2074, they will be sold based on business considerations, and the purchase price will be paid to the resolution fund via the share certificates. The resolution fund will apply the purchases price first towards the repayment of the obligation towards the policyholders of ECL old. If no such obligations are due, the resolution fund will use it to repay an outstanding balance under PIK facility. Any surplus after the redemption of the PIK facility will be used to repay the contributions made by Curaçao and St. Martin. Question 10. Who is currently the owner of Mullet Bay? Mullet Bay is owned by Sun Resorts, a subsidiary of EC Investments and part of the ENNIA Group. Question 11. Which map of the area has been used or is used for the sale of Mullet Bay? If and how far does it include the beach? The status of Mullet Bay is not changed by way of the Outline Agreement, and the Outline Agreement does not deal with particulars regarding the sale of Mullet Bay as part of its responsibilities under the emergency regulation. Noodregeling, the central bank will continue to evaluate the best way forward for Mullet Bay in light of the goal of the resolution, which is to reach the best outcome for all creditors of ENNIA, including its policyholders. Question 12. The central bank took the government of St. Martin to court to vacate the beach of Mullet Bay to remove the structures and the business. Can we receive the verdicts of this? Answer provided by the central bank. It is not clear which verdict is referred to. The central bank has never initiated proceedings in this respect against the government of St. Martin. It is not clear to us which procedure of Sun Resorts against the government of St. Martin reference has been made. The only possible court case we can think of is the one in which Sun Resorts lodged an appeal against a building permit that was granted to an entity called Majula's Snack BV. The appeal was declared inadmissible because the deadline for lodging the appeal had expired. The judgment of this case has been shared with Parliament. Question 13. Has the issue?
Honorable Minister, I will ask you to hold your last word. We have an interruption. Honorable Member of Parliament, MP Westcott.
Thank
you
you,
now have
Mr.
the floor.
Chairman, and good morning still, and a good morning to the Minister and her support staff, to my colleagues as well. Mr. Chairman, it's the Minister in her introductions mentioned that it's when the Minister's back is against the wall, that her resilience comes to the fore. I'm paraphrasing the statement, but it comes down to that. And I just want to mention how fitting that statement is on a day like today, not only for the minister, not only for individuals, but for St. Martin as a whole, giving the anniversary of Hurricane Irma today. So talk about our backs being against the wall and the resilience to be shown. Mr. Chairman, the minister throughout her answers and introduction has mentioned the issue of time constraint, and complexity of the issue at hand. And so I would like to know if there's anywhere in the document, the headline agreement and or the addendum, that mention is made of the possibility for St. Martin / the two countries, Curacao and St. Martin, to challenge any legalities that could further jeopardize the financial economic position of St. Martin, say, for example, for the period of 2 years. Time and complexity. Is there any way that we can seek to guarantee that if something comes up in, say, the next 2 years that jeopardizes the position of St. Martin, that can be inserted? Secondly, can we safeguard St. Martin from any liabilities, litigation that could arise from this three-party agreement? I'll leave my other comments and interruption for another opportunity. Thank you, Mr. Chairman.
Thank you very much. Honorable Minister. You have the floor.
Thank you.
From your hesitance, is it that you would like a short break or you would like to continue? Member of Parliament will take a 5-minute break. Meeting adjourned. The meeting? Minister? Yes. You have the floor.
I was at question 13 of MP Westcott. Has the issue of the road through Mullet Bay, should it be bought or expropriated to secure the road, has this been a discussion with the central bank? Answer, Mr. Chair. Sun Resorts is the owner of the road running through Mullet Bay. Any road works need to be discussed between Sun Resorts and the government of St. Martin. Question 14. Where has the appraisal come from? According to the courts, they appointed an appraiser. This is to come in September. Where does the 180 million value come from? Answer provided by the central bank. The stated amount of the 180 million is not an appraised value, but an estimate of future sale proceeds based on an appraised value and taking into account tax liabilities, etc. Question 15. Litigation contributed 230 million guilders as owned. What would that do to the financial calculations if that money would be given now? Mr. Chair, through you. The Joint Court of Justice of Aruba, Curacao, St. Martin, and of Bonaire, St. Eustatius, and Sabre recently confirmed in an interim judgment liability for an amount of 230 million guilders. Any proceeds from the claim on Ansari will be used primarily to meet the pre-emergency regulation liabilities. In the same judgment, the court appointed an expert to further investigate the historical value of Mullet Bay in order to rule on the substantial claims relating to, amongst others, dividend payments based on an excessive value of Mullet Bay. Any proceeds from the claim on Ansari will be used primarily to fund the deficit of former ECL and to meet the pre-emergency regulation liabilities, as the amount to be recovered from Ansari remains subject to the further success of the litigation and subsequent enforcement actions. The litigation award has not been included in the cash flow projections. It is noted that the annual contributions may, if certain conditions are met, be temporarily or permanently adjusted downwards by the parties by mutual agreement if the assets of former ECL and or the resolution fund are sufficient to meet the pre-emergency regulation liabilities expected to become due and payable in the next 5 years. Question 16. Can we get the financial picture of the structure that are being proposed? Answer provided by the central bank. Cash flow provided to Parliament via confidential route. And the final question by MP Westcott, question 17, company in public domain, so the Parliament can request financial information on this. Answer provided by the central bank. ENNIA will be a privately owned company. As such, some information that is provided needs to be handled confidentially. At this time, Mr. Chair, I would like to request a 10-minute break to regroup and then present their clarification round.
Can you repeat your request,
Yes.
Honorable Minister?
So at this point, no, I don't need a 10-minute break because we just had it, basically. So I am open for the clarification round.
So are you complete now with the answering of the questions?
Yes, I am.
Yeah? I thank you very much, Honorable Minister. I now go over to the honorable members of Parliament. We have reached to the round of clarifications, which we will go directly into at this moment. And I look at my list in terms of clarifications, and I would like to give the floor now to the honorable member of Parliament, MP Westcott Williams. You have the floor.
Thank you, Mr. Chairman, and a good afternoon once again, and good afternoon to my colleagues, good afternoon to everyone tuned into this meeting, and a special good afternoon and word of thanks to the Minister of Finance and her support staff for being here and for presenting the questions or answers to the questions as posed by members of Parliament. Based on those answers, Mr. Chairman, I have the following requests for clarification on the answers provided by the minister. The entire matter of St. Martin's contribution, and then my question is, when will the agreements, so the income from the central bank as well as the obligations of St. Martin, be reflected in the budget of the country? The minister, Mr. Chairman, referred to the question regarding profit and dividends to be paid by the central bank and stated that the last time dividends were paid was in 2022. Is it of 2022 or in 2022? And I ask this question because previous information indicated that the last time that the St. Martin received dividend from the central bank was in 2019. So did we also receive something in 2022, or was it another year paid in 2022? Mr. Chairman, I heard the answer to the so-called confidentiality and would like the minister to go further into this matter of confidentiality and how, especially the central bank as the regulator, will seek to comply with the confidentiality rules of an enterprise that is receiving public funds. So what can the Parliament ask for or not based on that fact? I had asked and would still ask if it's possible to receive, based on the headline agreement, a so-called organizational breakdown structure. I'm a very visual thinker in terms of seeing and understanding, and that's why I'm asking for that kind of an organigram, which would be an organizational breakdown, the companies, the responsible ones in the different companies, when are we talking foundation, when are we talking company, and the management structure of such. I would like, if not yet provided and or with Parliament, to receive the loan refinancing agreement made last year between the Netherlands and St. Martin. It is not, Mr. Chairman, I'm hearing a little murmur in the back about questions. The minister referred to it, and I'm asking to receive it, please. Thank you. I would like to understand what is meant with St. Martin having received the first right with respect to Mullet Bay. What does it specifically entail? What does this first right to purchase entail? And I want to repeat the question that was asked via interruption by MP Jacobs, and that is, are we to receive a redrafted headline agreement that will include the addendum, or it is two separate parts that we will have, the headline agreement as on the table and separate to that an addendum, or will we receive a text that will include the entire agreement? I would like the minister, through you, Mr. Chairman, to, having mentioned pre- and post-emergency liabilities based on the regulation, if a further outline of the pre- and post-emergency liabilities can be provided. The minister referred to the review after 15 years based on Article 7, sub 4 of the agreement, in answer to my question regarding an escape clause. And I would like the minister to indicate whether this agreement requires that the monetary union remains intact for the duration of the agreement. My question is understood, Mr. Chairman. Thank you.
Understood.
I want to follow up on the answer given regarding the motion passed by the Parliament of Curaçao regarding seeking the sale or promoting the sale of ENNIA new, and ask if the central bank is actually pursuing the motion. So in all that we're hearing and seeing and reading, is that motion being pursued actively? So is part of the the role of the central bank going forward that they seek. So not just in case somebody wants to buy, but they're seeking to sell it based on the motion of the Parliament of Curaçao. I want to get back to the matter of the Mullet Bay and my question regarding based on what plan has the central bank offered a part of Mullet Bay for sale? And the reason why I tie this into my question also regarding the court case, that based on what plan? So does the plan, based on what the CBCS is offering Mullet Bay or parts thereof for sale, in how far does it include the beach? That's a question I have been asking all along. And because the central bank, on behalf of Sun Resort, had asked about a building permit that was given. Was this building permit on or off the beach? The minister spoke of 230 million guilders as the verdict for the courts of appeal. Is that 230 million guilders thus far that verdict has yielded? I really want to ask if only, I understand the part that still have to come with the validation of Mullet Bay, but so I'm asking if that's if that's only the 230 million guilders. And then I asked, and the minister indicated, Mr. Chairman, that the cash flow will be presented to Parliament. So was it has been confidentially or to be presented to Parliament? Is that yet to be presented to Parliament confidentially? Mr. Chairman, that is it so far in terms of getting some clarification on the answers given. Thank you, Mr. Chairman.
Thank you very much, MP Westcott. I look at my speakers list. I now go over to the Honourable Member of Parliament, MP Jacobs. You now have the floor for clarifications.
Thank you, Mr. Chairman. Good afternoon to one and all once again. Mr. Chairman, I attempted or was moved to go to the interruption mic, but determined that I would better be served to bring it here in the clarifications so that it would be going down for the record and could be answered properly. Some of the questions answered by the current Minister of Finance left some ambiguity in my mind, and corrections can be made if I misinterpreted what was said. However, from what was said, in terms of one of the questions that was being answered from MP Arian was about time to find a new solution, related to time to find a new solution, and I understood the current minister as saying that the central bank misled the government of St. Martin with the calculations that had been made. I would like to understand if that is what was said, and if so, in what way was the government of St. Martin misled by the Central Bank of St. Martin? The minister also mentioned that data on policyholders were shared with her, and as such, as the former signatories to the current agreement, as one of the signatories, I am questioning now whether or not the information, you take decisions based on information provided at the time. So since the majority of the advisors are still with the Ministry of Finance, the cabinet as well, and also included, the advisors at the time also included, besides legal, also 2 financial consultants, one internal and one external. What exactly is being brought forward in terms of changes? That is not clear at all in the presentation of the answers that have been made. Statements are being made alluding to this addendum, this agreement, this new agreement, but it is not clear in what way. And when my question was being answered in terms of the risk, I would really want to reiterate that while the minister mentioned over and over that her opinion on this current agreement has not changed, that there is still required clarification. There is still clarification required as to what risk the current agreement contains that is now resolved within the addendum. How is that being averted and how? What is being averted and how? As I mentioned earlier, I find the statements very ambiguous, very heavy laden, some of the statements with opinions, and give no real information as to what exactly is the change that is coming forward. I understand that the minister said in her opening statements that the draft was sent to Curaçao and the Central Bank of St. Martin. I would like to humbly suggest, Mr. Chairman, to avert that this Parliament is not clear on what we are actually approving or disapproving, that if the presentation cannot be made in the public meeting as to the new addendum to the agreement, that we then take a break to have it presented behind closed doors so that this Parliament can proceed with clarity as to what exactly we are being asked to give our opinions and our approvals to. Further clarification, if I can go back to some other answers that were given. And then it's back to those calculations. A statement was made about the central bank making the calculations and mentioned that whether this can be trusted, since they are also partially responsible for, I'm using the word debacle, but whatever word was used, that is at ENNIA. How is the government of St. Martin moving forward if there is no trust between ourselves, current government, and the Central Bank of St. Martin? As then the following answer did go into seeking further information from the central bank, which was related to Mullet Bay and 180K, et cetera, et cetera. So it leaves me questioning more than feeling secure in the answers, Mr. Chairman, as to what is the current relationship between St. Martin and the central bank. Does this Council of Ministers now feel it necessary with, I heard that further clarity would be in the next shareholder meeting, to make significant changes in St. Martin's representation in the central bank to mitigate, even though these things happened when there was a previous management there. So basically clarification as to the relationship between Central Bank of Curaçao and St. Martin and the St. Martin government, more specifically the Minister of Finance, who has made some very strong statements here in the meeting today. So those are my clarifications at this time, Mr. Chairman, and I will yield the floor to you.
I thank you very much, MP Jacobs. I look at my list. I now give the floor to the Honourable Member Rosberg. You now have the floor.
Okay. Thank you, Mr. Chair. SG, thank you, Minister of Finance and support staff for answering the questions. I'm looking forward to the addendum. My dear colleagues, the ones present in the public today and the ones viewing online, I would like to have some of my questions clarified through you, Mr. Chair. Based on the questions, the answers to my questions provided, I have a questions in regard to the ongoing litigation. The minister stated through you, Mr. Chair, that there has been a litigation going on against accountants. I would like to get clarity on the matter if there also have been any litigation going on against auditors and or Mullet Bay appraisers. If so, if there's any outcome on such litigation, and if there's no outcome as yet, in what stage are we currently, and when is if the minister can answer that through you, Mr. Chair, a verdict to be expected, seeing that I understood, if I understood correctly, that there has been litigation going on since 2018-19, and also specifically because the minister stated through you, Mr. Chair, different people's names were mentioned and our organizations, businesses. I would like to specifically know how much cases are currently going on, so the amount of cases in regards to this matter. I thank you, Mr. Chair.
Thank you very much, Honorable Member Rosberg. I now give the floor to the Honorable Member of Parliament, Artwell Arian. You now have the floor.
Thank you, Mr. Chairman. Good afternoon to you. Good afternoon to Kafir. Good afternoon to my colleagues. Good afternoon to the Honorable Minister and her support staff and those viewing. Mr. Chairman, I almost thought we were still a little bit before elections, how the answers started off. And the Minister mentioned regarding trusting as a central bank, trusting information, but then I also question now trusting within the organization, because the Minister mentioned that there was no discussions between APS, myself, and the former cabinet regarding APS coming in to help purchase Malawi. So I'll ask the Minister to confirm that APS, if APS with an entity called CFG, which I think you're also aware of, that we were in a meeting. The meeting actually was about a lot of things. I believe also there's one other entity was also involved in it. That meeting also was sparked because of an article that came out in the paper regarding a sale of a partial part of Malawi. So I'm 100% sure that discussion happened. So now, again, I have to question now the trust within the organization in terms of information coming back to you. And in that discussion, we discussed possibilities. Of course, they said they cannot afford to do the whole thing, but through CFG, we would be able to look at other possibilities. So yes, that did happen. In addition, so before this meeting happened, there was a lot of discussion, of course, during the whole campaign about a new solution, a new solution, a new solution. But from what I'm hearing, and you keep emphasizing on an addendum, which also means a supplement, so you're basically supplementing what was there already. It's not a change to solution, it's not a new solution, it's an addendum, which could mean a lot. And we, as members of parliament, we haven't seen this addendum, so we're here today being told about an addendum, but we're not discussing anything. Matter of fact, the addendum has been sent to Curacao already, or central bank, according to what you said, but maybe the addendum should have come to parliament, because in the beginning of your statements, you mentioned that the former minister and the prime minister, for lack of better words, had a lack of respect for parliament with signing the agreement. But, and when we look at what happened in Curaçao's parliament approved and gave the free will to their council of ministers. It was a pre-approval. So even any change that happens in Curaçao government, Parliament has already approved. We decided to do opposite of that. We decided, no, we're going to make sure the Parliament has the power on decisions. So when persons compare what happened in Curaçao to us, yes, I agree. We made a better decision in terms of respecting Parliament, so that, yes, we did what we had to do to ensure that the financing, the refinancing is not in jeopardy. We made sure to ensure that the proposal is in order, but the final power, which now, in your position, your capacity, you have the opportunity now to even discuss an addendum. The only reason why you have the opportunity is because of the decisions that we made to come back to Parliament, and not that we have the full-on approval already of Parliament to do whatever we want, because the government of Curaçao, whatever the changes they make, is vascular. They don't have to go back to Parliament anymore. I also want to make it clear. Regarding, Mr. Chairman, a lot of confusion in the public. So I want to be very clear on that, because I think you mentioned it, but I want to be clear that it's not a loan. We don't have a loan in discussion right now. There's no loan in discussion. Through you, Mr. Chairman, the minister also mentioned the policyholders, and I would like to know if Parliament could get this information on the information that the Minister of Finance was seeking in terms of where they reside, where they work, and so forth. I would like to know if Parliament could also get this information. And as the MP mentioned, MP Scott also highlighted, also the minister's presentation, that we have a looming refinancing in October. So yes, the government still is, sitting under the gun of refinancing a loan of over 300 million guilders. And there is a risk factor to that. By not refinancing or not coming to a solution, we would then have more financial consequences than this loan. The interest alone of that would be so significant that it will impact Semanta for the next 30 years. With that being said, Mr. Chairman, more than likely in the next round, we are looking at a motion to handle some of the topics presented here today. And as the minister mentioned, that yes, we have to unite to stand up against what's wrong. And I believe the former government, if you look through the whole pandemic era, that's what we did. We fought tooth and nail with the Netherlands at every single point to ensure that Semata at all points had the best deal, or it's always in their best interest. That's why today, the last interest rate that we had is 3.2% in comparison to Aruba or Curacao. We've always fought. We've always. And that's why I said in the last meeting also, if there is a better solution, the minister could bring it, we could discuss. And I always would be in favor of the best solution for St. Martin, because it's not about me and myself. It's always about country first. That'll be all, Madam Chair. Mr. Chairman.
I thank you very much, Honourable Member of Parliament Arian. I see no more names on my speakers list for clarification. So what I will do, I would take a short 5. I saw a finger went up. MP Jacobs, are you requesting the floor for clarification? You have to stand. I will oblige and give you. Can you please make it short?
Yes.
Thank you very much.
It will definitely be short, Mr. Chairman. I have a question for you in terms of how we use clarifications. I heard one of the former speakers mention that in response to something the minister said, that the question is being asked. Isn't that then a follow-up question, and shouldn't that be in round 2? So that's my question to the Secretary General through you to the Secretary General to clarify, if possible, whether, because that could then set the tone as to how we deal with clarifications moving forward, if whatever the minister said can be then, and not necessarily based on the question asked. Thank you.
I'll remember, noted, I'll take it into discussion with the Secretary General. Honourable members, we'll take a 5-minute break and we will resume the meeting. Meeting adjourned. Good afternoon, and welcome back to this meeting. I now give the floor, but before I do that, honorable members of Parliament, in consultation with the honorable minister, what we have decided in discussion, and I had pressed the minister on this because some of the questions asked in clarifications are such of a technical nature that the minister made mention she will have to consult also with the Central Bank of Curaçao and St. Martin. However, the much talked about addendum, I encourage the minister to make a presentation, at least to the honorable members of Parliament, in relations to that. And also going forward, the meeting will be adjourned until the minister can come back with the full answers in clarifications to present to the honorable members of Parliament. But at present, I will now give the floor to the honorable minister so the minister can make the presentation to the honorable members of Parliament. Minister, you now have the floor.
And thank you, Mr. Chair, for allowing me the opportunity to first go through a few of the questions for clarification and then present the addendum as suggested. I want to first, the clarification question from MP Arian. He mentioned, through you, Mr. Chair, he is questioning or raising the trust in the organization along the lines of the statement that there were no conversations with APS, and that was a question. He mentioned the CFG meeting was about the sale partial part of Mullet Bay, but in my presentation, when I said that I had a discussion with APS, and APS informed me that there were no official discussions, it had nothing to do with Mullet Bay, it had to do with the ENNIA policy holders. So I just want to make clear that my statement in negotiation with APS has nothing to do with the sale of Mullet Bay. It was about looking for a solution for the policyholders of St. Martin and us not having to make this payment through ENNIA. As such, my statement remains the same. I do not think that all possibilities were exhausted in looking for a solution for St. Martin policyholders at that time. And then MP Westcott would like clarification through you, Mr. Chair, would like to receive the refinancing agreement made last year between the Netherlands and St. Martin, or we will confidentially submit the signed short-term refinancing agreement. And a follow-up question, clarification, cash flow overview is yet to be presented to Parliament confidentially. Answer, the cash flow overview from the current outline agreement was confidentially submitted to Parliament on July 18th, 2024. And finally, a question from MP Westcott. Are we to receive a redrafted addendum or just the addendum? So will we receive a new agreement that will include addendum or the old agreement with the addendum agreement? Answer, I will now present a short presentation on the agreement. Okay. In addition to the ENNIA agreement signed, there was also a short-term binding refinancing agreement signed in October 2023. This loan agreement is a binding document that officially linked the COVID loans to the ENNIA solution and specified that if no solution is found for ENNIA before October 10, 2024, the interest rate will increase from 3.4% to 6.8%. While I have consistently expressed disagreement with this linkage, the Dutch authorities referred to the document signed by the previous government of St. Martin as binding. Furthermore, there is a deadline of September 9, 2024, by which the new refinancing agreement must be signed. Although I have remained vocal and continue to disagree with this linkage, the previous government of St. Martin has committed to it, effectively binding St. Martin to this matter. This means there is no way to release ourselves from this agreement, and with the financial consequences in mind, it limits the possibilities for alternative solutions to address the needs of our policyholders. Nevertheless, even with this new information, I remain firm in my stance that we will not be pressured into signing anything that is not beneficial to St. Martin, nor will I later claim that my hands were tied or behind or my back was against the wall. After my presentation in Parliament, it became very clear to the Central Bank in Curacao that as the Minister of Finance, I will not accept any nonsense presented to me, nor will I sell it to the people of St. Martin, fully knowing it is not in their best interest. Initially, they claimed that no changes could be made, but soon realized that neither Marinka nor St. Martin would be moved. As a result, they proceeded to make adjustments when it became evident that St. Martin was being taken advantage of in the ENNIA agreement that had been signed. I pushed for more information and shifted my focus to ensuring that St. Martin is only paying for its own policyholders, not ENNIA as a whole. My focus was on getting the best for St. Martin now and ultimately securing today for the future. With this being said, I looked at the matter from a holistic point of view and asked myself several questions. Would I have signed the HLA on April 11, 2024, without Parliament of St. Martin approving this agreement? The answer, no. Do I wish I was a part of the discussions for the HLA and the refinancing of COVID loans? Yes. Do I think I would have done a better job? Yes. Would I simply have accepted the conditions of the Dutch tying the COVID loans interest rate to solving a privately owned entity and signing the refinancing agreement? No. Would I go as far as to question the fact that the Dutch got approval from the EU for the impact it derived from COVID and received such as a grant? Yes. Would I ask if the loan to St. Martin and Curacao was a part of this grant request that the Netherlands received from the EU? Yes. Picture the fact that the Netherlands still having to go to the EU and request financial assistance. What then do we make of St. Martin as a small developing state? COVID was something that no one expected or planned for. It was a surprise to us all. When the Netherlands received the grant, St. Martin received a loan at an interest rate of 3.4% and a contract binding us to a higher interest rate of 6.8%. Why not, in good conscience, alleviate this burden by debt swap, which would give us the opportunity to invest this money towards the much-needed investment to St. Martin in education, health, or renewable energy, and the list goes on. All missed opportunities from the prior government in negotiations whereby assisting the people of St. Martin. Allow me to share the financial realities we are now in. Next year, there will be a loan expiring of 73.5 million guilders. Can we repay it? No, we can't. As such, we will have to refinance it. Again, we would have to ask the Dutch to refinance. But guess what? In 2029, another loan of 58.7 million will be expiring. Guess what? In 2030, there will also be another loan expiring of 78.6 million guilders. In 2032, another loan of 30 million guilders will be expiring. In 2035, two loans totaling 100 million guilders will be expiring. And 2040, there will be a loan expiring in the amount of 50 million guilders. In the agreement signed by the previous government in October 2023, the following has been clearly stated, and I have shared this agreement with the members of Parliament, where it was agreed that if we do not have an agreement on the ENNIA saga prior to October 2024, the following will apply. 10.6 million interest, of which the interest rate is 3.4%, but will go to 6.8 in 2025. 10 million in repayment of loans. Total 20.6 million guilders due in October 2024. If an ENNIA solution is found, 9.1 million in interest.
Honourable Minister, I will ask you to hold your words. We have interruption by the Honourable Member of Parliament, Duran. press your mic, yeah.
Thank you, Mr. Chairman. Good afternoon, Honorable Minister. I would like if you can get some clarity on when these loans were taken up. Thank you. All the loans that were just mentioned.
Thank you very much. Minister?
To answer the question by the Honorable MP, these loans were taken out, most of them were taken out prior to 2010.
Minister, you may proceed. One moment, Honorable Minister. Member of Parliament Erin, you have the floor for interruption.
Thank you, Mr. Chairman. Yes, it's very interesting to hear about the loans. No, the mic on? Yes, so I'm happy that the minister brought forth all these loans that are expiring in the future and where this debt came from. So what I would like to know is the dates of these loans and actually which government was in charge then or running the show then when these loans were made or taken.
Honorable Minister, you have the floor.
As stated, it's basically the same question. Like I stated, the most of these loans were taken out prior to 2010. The specific dates and governments, I could always provide the Honorable MP with.
You have the floor, Minister.
As I was saying, I could provide the Honorable MP with the information at a later date with the specific dates, specific government, etc.
Honorable Member, you have the floor.
Thank you, Mr. Chairman. I hope this isn't seen as a second interruption because I still didn't receive an answer. The reason why I'm putting emphasis on it is because if you're going to make a statement, then I think that you should be full out with the statement in terms of at least the year, because that would then give an indication. So if we have to pause for a few minutes, we're here handling the people business, so I look forward to getting a response before we proceed.
No.
Thank you very much, Honorable Member. And yes, it is your second interruption. I've listened to the Honorable Minister, and in providing the date, I believe she said prior to 10-10-10. However, I will give the Honorable Minister the floor once again to answer the questions, and then you can move on with the presentation, Honorable Minister.
Thank you, Mr. Chair. Again, I will reiterate. The loans mentioned, most are prior to 2010. The information will be provided in a subsequent meeting with the specific information as it relates to the who, the when, and the
Minister,
what.
you have the floor to proceed.
Thank you. Total 20.6 million guilders due in October 2024. And that's if there is no solution found. If an ENNIA solution is found, 9.1 million in interest, 2 million in repayment of loans, total 11.1 million due in October 2024. As such, the financial effect of not finding a solution which the previous government signed off on would result in an additional 9.5 million guilders to be paid in 2024 and an additional 12.6 million guilders yearly in interest on top of the already agreed upon yearly 9 million guilders, which totals a yearly interest of 21 million guilders on the COVID loans if no ENNIA solution is found. It is very important to note that the signed refinancing agreement by the previous government explicitly states that no discussions or negotiations can be held regarding the interest rate of the COVID loans when signing the long-term refinancing agreement. This is why I have consistently emphasized that While I do not agree with the linkage between the COVID loans and the ENNIA solution, the previous government of St. Martin signed an agreement linking the two and prohibiting any discussions about the interest rates, which will increase if no ENNIA solution is found. My goal has been to ensure that this solution is as beneficial as possible to St. Martin. I remain very clear on this. Yes, I want to protect St. Martin's policyholders, but no, St. Martin will not save ENNIA as an entity. Upon receiving more information, I discovered that under the signed outline agreement, we were paying for more than just our policyholders. We were also paying for BEST policyholders, Suriname policyholders, and ENNIA's operational costs. Keep in mind, ENNIA is a company based in Curacao with approximately 150 employees, and all taxes and social premiums are paid to Curacao. Is St. Martin receiving a share of those taxes? Are they planning to increase the number of employees at the St. Martin ENNIA office? No. So why should we bear the costs relating to ENNIA's operations if we are not benefiting from its continuation? When I asked what benefits St. Martin was receiving with regard to Mullet Bay, I was told that none were provided because St. Martin previous government did not ask for any. The following changes were made and is included in the addendum. St. Martin will not be paying for the BEST policyholders. St. Martin will not be paying for Suriname policyholders.
Honorable Minister, again, I'll have to ask you to hold your words. We have the Honorable Member of Parliament, Ms. Jacob, for interruption. You now have the floor.
Thank you, Mr. Chairman. Sorry that you started with
You have to
the
press
actual
it.
presentation. Press it again?
It's on? Yeah, go ahead.
Green, right?
Very well.
Yes. I'm sorry that the minister had to stop with the actual presentation on the addendum to the outline agreement. My question that wasn't clarified was specifically what are the risks? And I'm not sure whether the answers just given pertain to the same risks. Hindsight is always 20/20. We're a year further. So it is, for me, disingenuous to bring forth information that was not privy to that discussion last year. No, we have been having several discussions with the Dutch government in terms of debt swap, et cetera, for COVID loans and hurricane loans, separate to this whole situation. And at no point was St. Martin was like, yippee, it's a great linkage. We always had a situation with it. The conditions that were added was higher interest rates. So I am saying, standing here and saying that I would not have agreed and I would not have done that, so that means you would have subjected St. Martin to the higher interest rates, which were just being explained. And I think the public of St. Martin is hearing a lot of convoluted information. It has to be clear to average people on St. Martin what is being discussed, what the risks are, what the risks were then, and what the risk is now if in September 9th or October, whatever date, a new refinancing agreement isn't had. I also asked about, or I was saving that question, but I see now part of the presentation is talking about where the policyholders are. But at the end of the day, Mr. Chairman, information has to be provided in a way that is clear for the people of St. Martin. That's why I use this opportunity to interrupt and hope that further clarification can be given.
I thank you very much, Member of Parliament, and that's exactly the purpose for the interpretation. We now go over to the Member of Parliament. We go over now to the Member of Parliament, MP Jacobs. You have the floor. Sorry about that. MP Westcott Williams, you now have the floor.
Thank you, Mr. Chairman. Mr. Chairman, briefly, I understood the minister to state that the agreement for the refinancing of the COVID loans is a confidential agreement, the one of last year. That's the most recent one. Did I understand that correctly? And if so, why? Why is that agreement for the refinancing of the COVID loans confidential? And secondly, this is an assertion, and that is given all that I've heard it been referred to as blackmail, as putting our backs against the wall, as modern day slavery, And I, on those statements, ask if it is not time that we, in a very objective way, investigate, have review, and challenged the constant tying, linking, to use the words of the minister, of matters such as the loans, COVID loans, and others, to get certain issues pushed through, like is now being done again with this ENNIA agreement. So I would like the minister's opinion on that matter, if she can provide that now. Because and again, it's an assertion, interruption, assertion, I believe that is what the Parliament should be doing at this time. Thank you, Ms.
I thank you very much to the Honourable Member of Parliament, MP Westcott. Honourable Minister, I know you have taken note of the suggestions. I will now give you the floor to continue your presentation. However, if you can delve into some of the requests and questions that was asked, I now give you the floor as well.
Thank you. Mr. Chair, I think at this point I should go back to the changes that were made and is included in the addendum, just for clarity. St. Martin will not be paying for the best policyholders. St. Martin will not be paying for Suriname policyholders. St. Martin will not be paying for the operational expenses of ENNIA. St. Martin agrees to saving only its policyholders. St. Martin will receive priority in purchasing Mullet Bay. There will be a separate administration for St. Martin, and St. Martin will receive a yearly report by an external accountant on St. Martin's portion in the resolution fund. This report will be provided yearly on April 1st. St. Martin will have a separate peak facility to prevent any mixing of costs. St. Martin will save millions in interest costs due to its limited use of the peak facility. And most importantly, the above changes ensures that we are covering the policyholders of St. Martin and not the ENNIA and the entity ENNIA.
Honourable Minister.
This will
MP
probably be deemed a technical
Jacobs.
question again, but that's why I wanted the information before this information was presented, Mr. Chairman. What criteria was used when it was determined that there were 3,000 St. Martin policyholders? What qualified these 3,000 policyholders to be deemed St. Martins in the first place? Because they were deemed to have St. Martin policyholders and Curaçao policyholders at the time. What is this discussion now about BESS? Is it people that left St. Martin and then went to retire in the BESS, but they bought their policy in St. Martin? And similar for the Suriname policyholders, how did they become involved in the St. Martin ones in the first place? That needs to be very clear.
I thank you, MP Jacobs. I see Member of Parliament Arian also would like an interruption. Honourable Member of Parliament, you have the floor.
Yes, Mr. Chairman. So following up to the questions posed by MP Jacobs, in addition to that, were the policyholders of the Suriname BESS, were they part of the whole entity before? So did they pay into the entity before? Because at the end of the day, it's a entity. When we were negotiating this, they made it very clear to us that you can't discriminate. So in addition to that, this addendum is St. Martin's position. Has this already been agreed for by Curaçao, the central bank, and so forth? So I don't want the impression that leaves here today that, oh, this is the new addendum, because I'm pretty sure it still has to be approved. So I want to be clear to the public also, this is our position, but it's not a guarantee that this is going to happen. So I want to be very clear on that also. In addition to that, St. Martin having priority to purchase Mullet Bay. Right now we have the priority. If the government has the money right now to purchase Mullet Bay, so I ask a question now, does the government have the money to purchase Mullet Bay now? Is there any plans to purchase Mother Bay in the next few months, because right now we have the possibility, because the Mother Bay isn't ours. Mother Bay is a private entity. And also, again, I'd like the minister to confirm with the current, and I believe the current entity, I believe Martis, we also as a COM told them that we will always have first priority. So it isn't something we did here. We did as a COM a year prior to that already. So I want to be clear also, you can even go back and check the minutes of that meeting, if the government, the council ministers then did not already say that we want and will have first priority to purchase Mother Bay.
I thank you very much, Member of Parliament Arian. To the honorable members of Parliament, and also I would like to, remind you that this is the clarification round, and many of that came about because the minister needed much more time because of the technical nature of the questions that was asked. However, I asked the minister to make sure, give us some semblance of this addendum. So I would encourage the members of Parliament, if we can please allow the minister to continue with the presentation, and then we can proceed from there. No. She will come today. I will ask the honorable minister to answer many of the questions. However, like I made mention earlier, most of the questions asked are of a technical nature, where the minister also need much more information. Minister, you now have the floor. Minister?
Yes. In continuing with the addendum,
Honorable Minister?
yes.
You also need to answer to the interruption as well.
So to answer the interruptions, like the chair of Parliament indicated, these questions are basically on a very technical level, and I would have to come back and respond to the questions from MP Westcott, MP Duran, MP Arian, and MP Jacobs.
Members of Parliament, I'll give you the floor shortly, MP Arian. But again, like I made mention earlier, can we please allow, let's have some order, please. Order. Honorable Minister, you have the floor.
Thank you. Again? Yeah. Okay.
Honorable Minister, I'll ask you again to hold your word. I now give the floor to the Honorable Member of Parliament. Utley, you now have the floor.
Thank you, Mr. Chair. Mr. Chair, while I do somewhat agree with your sentiments of letting the minister finish, what I do not understand is, while listening to the meeting, there was a lot of accusations thrown in former government, this and former government, and research, and the government didn't research. And now, when questions are being asked, everything is too technical. Questions as simple as, you made an addendum that you're not paying for the best policyholders, so the question is, what is determined? How did you come to this addendum that you're not paying for the best policyholders? If someone works in St. Martin, now resides in the best, are they not to be paid? It's not technical. Then we scream about political, and election is over, but on my way here, I'm hearing a whole propaganda about 70 years and 70 years later and 70 years to continue. It cannot be when we want, and then now when we're in opposition, the rule is changed. I know the saying, new chair, new rules, but I hope that we can get the basic questions as, you're saying you're not paying for Suriname, you're not paying for the best. Why? How did this come about? And a simple question was asked. This is an addendum. We cannot leave St. Martin thinking that this is law. Was this approved by the central bank? Was this approved by Curacao? Those are not technical questions in my point of view, Mr. Chair. So I look forward to some sort of answers, not because we're opposition, we can't be answered. Thank you.
Noted to the honorable member. I myself won't be here too long as chair too as well. However, like I made mention earlier, is not that the honorable minister will not get into answering some of the questions. What I am asking as indulgence is to allow the minister to finish the presentation, and then what can be answered will be answered. That's what I'm saying. I understand the point. However, I'll give the floor now to the honorable minister. Minister, you have the floor.
Thank you, Mr. Chairman. I need to respond to MP Otley. And the reason why I need to respond to MP Otley,
Honorable minister, then you'll have to respond to all that was asked. So that's why I made mention earlier, is either you finish the presentation, honorable, you finish the you go through the presentation, and then you go into responding to the honorable members of parliament. So you have the floor to continue with the presentation. Thank you.
Again, I will repeat the changes made as included in the addendum. Again, St. Martin will not be paying for the best policyholders. St. Martin will not be paying for the Suriname policyholders. St. Martin will not be paying for the operational expenses of ENNIA. St. Martin agrees to saving only its policyholders. St. Martin will receive priority in purchasing Mullet Bay. There will be a separate administration for St. Martin, and St. Martin will receive a yearly report by an external accountant on St. Martin's portion in the resolution fund. This report will be provided yearly on April 1st. St. Martin will have a separate peak facility to prevent any mixing of costs, and St. Martin will save millions in interest costs due to its limited use of the peak facility. Most importantly, the above changes ensures that we are covering the policyholders of St. Martin and not the ENNIA entity. The financial savings for St. Martin achieved via the addendum is 37 million guilders, 5 million saving by not covering BEST and Suriname, 15 million savings by not covering the operational expenses, 14 million savings by reduction in expenses and hence a positive cash balance at the end, and 3 million savings in interest due to a separate peak facility and limited use of the peak facility. The total savings for St. Martin amount to 37 million guilders, which represents approximately 30% savings from the initial outline agreement. While these savings may not be as significant for Curacao, they are highly significant for St. Martin. This ensures that we, St. Martin, will not, while not benefiting from the continuation of the ENNIA group, are focusing solely on protecting our own policyholders. Furthermore, it guarantees that we will not be saving ENNIA as a company, only contributing to our policyholders, while also ensuring that St. Martin will have first priority in purchasing prime location, that of Mullet Bay. All things considered, your positive decision towards this addendum would indicate you choosing St. Martin and putting its people first. At this time, Mr. Chair, allow me to thank you and the honorable members of Parliament for your attention.
I thank you very much, Honorable Minister. I would now encourage you to go over through the question that you can answer that was asked during the interruption by the honorable members of Parliament.
Most of the questions, Mr. Chair, from the honorable members of Parliament basically tie into, especially the best, if I could recall every one of them, the best in Suriname and where these policyholders come from. And that's exactly my point. When I was faced with finding a solution to this ENNIA saga, we were first told, you cannot make any changes. This is what it is, no changes to be made, and here we are today talking about an addendum. So that in and of itself speaks volumes of the work put in between myself, my team, as well as the central bank, its technical team, Curacao, to finding the best solution, well, for me, for the people of St. Martin and its policyholders. It meant digging. It meant going after information. It meant seeking what didn't make sense. And it's only after seeking, it's only after asking the necessary questions, we were told the hidden things that were left in that peak facility, such as the Best Islands, such as Suriname. If there were nobody asking these questions, and I can't help it if I wasn't a part of the previous government then, to really seek and ask these questions, we would not have known that Best was included, that Suriname is included, that today members of parliament are now asking where these Best Islands come from, where the Suriname policyholders come from. So it was basically by going in, really assessing the situation, seeking what was told to us, and really finding out from the central bank these hidden, very basic lines that we needed to understand what we were really paying for, and of course, the execution costs of the company ENNIA in and of itself. There was a question by MP Otley where he talked about, on his way here, he heard about the 70 years. It was a question posed by Member of Parliament, Mr. Marlin, and I believe all questions that were posed on June 27th were answered, and that was a question that I needed to answer to him as well, politics aside.
You also had a few questions from the Honourable Member of Parliament, MP Jacobs, concerning the loans and the period of time then, now, and where, yes.
Right, and so that information concerning the loans, I think it was MP Duran asked those questions concerning the loans as to the when. I really would have to get back, MP Duran, with all due respect to you, in giving you the specific dates, the what and who was in government at that time. You'd share it when?
Minister, are you complete with
Yes, I am.
the questions?
Yes.
Honourable members of Parliament, I would now adjourn this meeting until further notice, giving the Honourable Minister time to come back with the answers in clarifications. I now adjourn, meeting adjourned.
Thank you.
Sorry. Welcome back to the meeting. As was made mention earlier, the minister will take the time to come back and answer the questions that was posed by the honorable members of parliament, hopefully not too long. So with that being said, I will now officially close. I will now adjourn this meeting until further notice. I would like to thank everyone for being here. Have a good afternoon. Take care of yourself. Meeting adjourned. Bye.